filed an appeal and you needed a transcript, and there was some kind of conflict that was going on with regards to payment of that transcript. Was that transcript paid for?
Yes, that's all been taken care of.
Okay, how was it paid for?
Through Venmo.
Through Venmo?
Yeah.
Okay, and so when was it paid through Venmo? She can't testify, so do you have an idea? Because
a month ago.
Order went out on January 6th, 2026.
It was before your order, before the 15th. I think it was the 10th, maybe.
That's
or the 6th.
what I recall, because otherwise I wouldn't have done the order.
I know I did.
After that.
I did the payment the day of the order.
The day of the order.
Yeah.
Okay, so you paid for the transcript by Venmo the day after you received my order.
No, the day of your order. I think it was the day of your order, the same day.
Same day of my order. So my order went out January 6th right away in the morning, and then you paid for the transcript by Venmo later that day?
I think your order went out in the afternoon, and I had paid, I think, just before your order.
I mean,
actually,
that's easy to check, Mr. Elsiams.
I'm sure
I can definitely get that and get it all verified. But that's not my understanding. It wasn't paid for. Otherwise, I would not have done an order. And so my order did say pay for the transcript. This is all bold and capital. Payment for the transcripts be made on or before January 15th, 2026. And yada, yada, yada. Then again, and all bold and capital, payment shall be made by cash underlined or money order underlined, payable directly to the court reporter. And you paid by Venmo?
Well, we had been discussing payment for a month, and she said that she accepted Venmo, but would be a fine payment. So that the day of your order, that's when I paid via Venmo, because I established a Venmo account and I paid her via Venmo the same day of your order.
All right. So you paid the same day. All right. Of my order. So you didn't do what you wanted to do and paid by Venmo, even though the court ordered you specifically to pay cash or money order because of the difficulty that arose between payment. Correct? Correct? Yes or no? Yes or no?
No, we were speaking for a couple months, and she said that Venmo was acceptable
payment. I'm not going to have her in the middle of it. I just know my order went out on January 6th. You paid January 6th by Venmo.
Right. Yes.
Right. Okay. All right. So with regards to the motion to stay, there are things that the court has to follow. There are, and State v. Guddenschwager, 191 Wisconsin 2nd, and it's GUDENSCHWAGER, 1995. It says the court must look at 4 specific things. 1, the likelihood of success on the merit, irreparable harm to the other parties, and the public interest. All right, and I've heard the arguments of the parties, and I understand, Mr. Olsams, you believe that this is going to create new law and precedent, and the Court of Appeals will make everything right and will define nuisance and will overturn this court's decision and the orders that I have, not just one, but 2. I have two orders in this case, 2 separate orders in this case. Court here, I don't find that you have shown that or demonstrated a strong probability on appeal that it will be successful. The court thoroughly went over what nuisance was. The court thoroughly went over the violations that were occurring while you were renting your property out to other people. Very, very clearly in my first decision, because my first decision, it's 26 pages long. Granted, it's not all 26 pages. It's 15 pages of the court analyzing the law, interpreting the law, and analyzing the facts of the case, and then putting it on a decision in order. The other pages from page 16 to 26, those 10 pages, they were here to help you out. A guide to renting out your property for overnight stays. Protect yourself by knowing Wisconsin's law for short-term rentals. I gave you that pamphlet, so it would explain the law, explain what you need to do. So that was there. The second thing was the Department of Agriculture, Trade and Consumer Protection, the tourist rooming houses, and what you must do to follow that law for the DATCP. Then the court also provided you with the permit application for the tourist rooming house. So you could have that along with another brochure, the Wisconsin Short-Term Rentals Law. And it has little arrows and things and little boxes, and it makes it really easy to follow to make sure that what you need to do to comply with that law. The court then also provided the short-term rental license application for Burnett County, clearly gave it to you, showed what you needed to do, had it right there. And I also provided the Burnett County licensing requirements right there, so you could have them right there with the additional provisions. And then beyond that, provided Burnett County Ordinance Section 30-455, short-term rental, which clearly goes over what a short-term rental is. And I went beyond that because there's issues and arguments with parking. I put in Burnett County Ordinance Section 30-480, parking as it relates to off-street parking. And here it would be with short-term rentals. Very clearly laid it out because you were very clearly violating the law. That was well proven, directly proven. I don't think it could have been proven any more clear to the court that you were violating Wisconsin state law and Burnett County ordinance. And the court did state that. And then the court did, that's why I entered the injunction with those requirements that you, again, I will read it to you, that what my order says, word for word, my order says, as such, the court hereby issues a permanent injunction until such time that Mr. and Mrs. Olsiums complies with and receives the state DATCP rental license and the Burnett County rental permit and continues to do so annually as required, and until such a time that the above depicted nuisances can be abated. So there's two things here. I hear your argument about nuisances. You want the Court of Appeal to look and see, wow, Judge Mogan doesn't understand what nuisance law is, and that's fine. But then there's that other first part that the court clearly says, permanent injunction, meaning not one, not two, not three, zero. No free days, no.
This is where things get serious. A permanent injunction isn't a suggestion. It's a hard legal stop. No loopholes, no creative interpretations. If the defendant thought they found a workaround, the judge is about to shut that down fast. Question for you. Do you think this was confusion or calculated risk?
Days, no, I'm going to give it to you for 30 days, but I'm only going to charge you for 1 day. But don't worry, it's going to be $30,000 for that 1 day. But I'm only renting you for 1 night. Clearly says permanent injunction until such time that you and Mrs. Olsiums, that you comply with and receive the state DATCP rental license, that you do that, and the Burnett County rental permit, and you continue to do so annually. So you stay compliant. The order does not give you authority in any way, shape, or form, to rent at all, even with the Burnett County ordinance of, having, or the state, which says 10 nights or less, or 10 days or less. Nothing about that. And the court's order clearly defined all of that. I had all of that information in my order. So if I was going to give you authority to say, all right, you can rent it for 10 days or less. I mean, really, you can rent it for 20 days as long as you give them 10 for free. That's totally fine, but charge them for the 20, but you only rent them for 10. I said nothing about any ability to rent at all. It's a permanent injunction, permanent until you do those two things. All right. Until you do those two things. You did not do any of those things. Instead, you rented it. You were found in contempt. You had far more days for the rental at the last contempt hearing. So the court found you in contempt. And this case, you're like, I'm going to outwit the legislature. I'm going to outwit the Burnett County Board. I'm going to outwit Judge Mogan. And
oof. This is a rare moment where the judge goes from neutral referee to direct call-out. Legally, this matters because intent can influence how harshly the court responds. The judge is basically saying, this wasn't a mistake. You knew what you were doing. That's a dangerous place to be in contempt proceedings.
Attorney Anderson, that's what you thought. You thought you're smarter than everyone else in the room. You are not smarter than anyone else in the room. I was number 2 out of 105 people in my law school graduating class, okay? I know how to analyze the law. You were trying to be sneaky and deceptive, and you were trying to get away with something that is clearly not legal or correct. You rented over the 10 days again. Again, whether it's 11 days, whether it's 13 days, whether it's 14 days, you admit on the stand and at the table it was 10 days. I rented 10 days, exactly what I said I could do in the ordinance. I did not do above. But I did give them 5 free days. Can't remember anything else, but I gave them 5 free days. So that's 15 days. 15 days you admit to. 15 days you admit to. I don't even have to go with any evidence or anything that's been filed or served by or received by the court from Mr. Anderson. You admit to 15 days. 10 you rented for money and 5 you gave for free. Even if I were, Mr. Olsiums, to take you and believe you, that is your understanding. And even if the court were to go, I don't think I wrote my order as clearly as I should, which I did though. Even if I took that and listened to your argument, you violated the ordinance. Free days count, Mr. Olsium. Free days are not free days, especially when you're charging $6,980.48 for 2 days. What fool's gonna pay like almost $3,500 a night? A fool would pay $3,500 a night. It's absurd. It's ridiculous. And I can't believe you think that a court would fall for it. The Court of Appeals will not fall for it. I'm telling you that. They're very smart. Probably smarter than I am. They do this all the time. They're not going to fall for your shenanigans. They're not going to. You're nodding your head up and down. I don't know what that means if you're saying yes or not, but that's where we are. You violated the order again. So I do find you in contempt for these violations. As to the sanctions and whether or not the court orders attorney's fees, etc., I am going to stay on the sanctions part of the decision because I don't have that information in front of me. And with the last contempt, I did deny attorney's fees for particular reasons, and I can't just go off of this is how many hours it is. There has to be the other arguments per the statute and the Supreme Court rule. But I do find you in contempt. Further, beyond that, you didn't follow my August 29th, 2025 order. Very, 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 very clear. $2,500 for each, capitalized each, violation, parentheses 2, totaling $5,000, plus a 45-day jail sentence for each, capitalize each, violation to be served consecutively. Serve 1, serve 2, for 90 days jail in parentheses. The jail sentence may be purged. You may get out of that completely. I don't have to do it. That's good. I don't want to go to jail. On the following conditions: full compliance with the October 4th, 2024 court injunctive order. One way that you can purge it, plus the second way, full payment of the court sanctions, fines, and fees within 60 days. Court calculated it. I did it twice. I did it 3 times actually. The deadline was October 27th, 2025. October 27th, 2025. Let's get to that. That was a Monday. You had until October 27th, 2025, Monday, to pay that, to purge your jail. You didn't do that. Moreover, even still, your motion that you filed to stay all orders pending appeal was filed on November 3rd, 2025. Beyond the deadline that I gave you to purge. Beyond that, it's late. It doesn't count. You may want me to stay the other decisions, that maybe the other parts of it, I guess. I don't even know, because I'm going to tell you your motion, your petition here, it's hard to understand. Doesn't even make sense. And you're just spewing things that you think and you interpret as the law, or actually what you want the law to be and how you want it to be. So you can follow it and you can do what you want. So the motion to stay is denied. I don't find that you've met any of the factors that you need to meet. I don't think there's a high likelihood of success on the merits. I just went all over that. I don't think you're going to be irreparably harmed by if the court doesn't stay it, because it sounds like you're going to do what you want to do anyway, and you're going to try and do it and just hope you don't get caught. Harm to the other parties, harm to all of the other plaintiffs and all the other people here is higher than yours, because you continue to do these things. Not only, we're not just talking about the sewer. That went away. That was the only time I heard about it. Then I heard about the damage to the trees. I heard about the urinating in front of their camera. I heard about all of those other things in which the court found you nuisances, you violated, you did things that interfere with their ability to enjoy their property. The public interest here, I have to weigh the public interest. And here the best interest of the public is not to stay. It's to continue.
And here it is, the moment everything catches up. Contempt isn't just a warning anymore. It has real consequences. Jail time, fines, and zero patience left from the court. Final question. At this point, do you think anything could have changed the outcome? Or was this inevitable?
To have these specific parameters in place that you must follow, because it's been shown that you do not follow. You don't follow the law. You don't follow what the legislature says. You don't follow what the law enforcement says. You don't follow what the court says. You don't follow what anyone says but you. So I'm denying your motion to stay. And I'm finding you in contempt of the court's contempt order. I'm imposing those sanctions. You failed to pay $5,000 by October 27th, 2025. That means that the jail sentence stays 90 days in custody immediately. As to the other parts of the order, the court will again stay on that and we'll get it out. So you'll be remanded to custody for your 90-day sentence. You failed to purge. You did what you want.
Your Honor, can I purge right now?
No, you didn't have the money. You literally just said on the stand. Stop.
I have a credit card.
Stop. You literally said on the stand or on your table under oath, but I don't have the money. I can go back on a transcript. I can go back. You said those words.
I don't have it. I have it on a credit card though.
That's money. You could have paid it on a credit card by October 27th, 2025. But if you read my order clearly, words are clear, by October 27th, 2025, then the jail goes away. It's February 6th, 2026. Far beyond that. The court's enforcing it. You're remanded to custody immediately, 90 days. Thank you. We're adjourned. Sometime you have to start abiding by the law and orders of the court, Mr. Olsiams.
Can I purge, Your Honor? I have a lot of business and things that I wouldn't.
Well, what you can do is you can pay it and then you can write a letter to the court and then I'll consider it. But right now my order is very clear, very clear. The purge condition was very clear. So if you would like to pay it and then you would like the court to, it's called reconsideration, you sure can do a motion to do that.
Can I do that right now?
No, you have to go up to jail.
How would I make?
Go up to jail.